Hello everyone, I'm Aratrika Bhaumik and I welcome you all to the final episode of LiveLaw's exclusive series titled 100 Important Supreme Court Judgments of the Year 2022. For those of you who are not aware, it is a 5-part series where we cover 20 important Supreme Court judgments in each episode. If you haven't watched the first 4 episodes of this series, you can check out the description box below where the links to the episodes have been provided. So without further ado, let's begin. In a judgment having wide ramifications in the IBC litigation, the Supreme Court in the case titled Vidarbha Industries Power Limited versus Axis Bank Limited held that it is not mandatory for the adjudicating authority to admit an application to initiate corporate insolvency resolution process even if a debt existed and the corporate debtor is in default. The court observed that ordinarily the adjudicating authority, that is the NCLT, would have to exercise its discretion to admit and initiate CIRP on satisfaction of the existence of a financial debt and default on the part of the corporate debtor in payment of the debt unless there are good reasons not to admit the petition. However, such discretionary power cannot be exercised arbitrarily. The bench comprising Justices Indira Banerjee and J.K. Maheshwari cautioned in this judgment. In a significant judgment, the Supreme Court in the case titled Dashrath Bhai Trikam Bhai Patel versus Hitesh Mahendra Bhai Patel and others has held that no offence of dishonor of cheque under Section 138 of the Negotiable Instruments Act is made out if the cheque is presented for the full amount without endorsing the part payment made by the borrower after the issuance of the cheque. The Supreme Court held that the sum reflected on the cheque will not be the legally enforceable debt as per Section 138 of the NI Act when it has been presented for encashment without endorsing the part payment. Part payments must be endorsed on the cheque as per Section 56 of the NI Act. If such endorsement is made, the cheque can be presented for the balance amount and the offence under Section 138 of the NI Act will be attracted if such cheque with endorsement of the part payment gets dishonoured, explained the Supreme Court in this vital judgment. The Supreme Court in the case titled Aishat Shifa versus State of Karnataka and others passed a split verdict on a batch of appeals challenging the restriction on Muslim girl students wearing hijab in educational institutions in the state of Karnataka. Justice Hemant Gupta dismissed the 26 appeals filed against the judgment of the Karnataka High Court, which had held that hijab was not an essential practice of Islam and had allowed the ban on wearing of headscarf in educational institutions in the state. Expressing the divergence in his opinion, Justice Sudhanshu Dhulia had set aside the Karnataka High Court judgment and had held that the entire concept of essential religious practice was not essential to the dispute in question. The Supreme Court of India in the case titled People's Union for Civil Liberties versus Union of India has directed that no one should be prosecuted under Section 66A of the Information Technology Act of 2000, which was struck down as unconstitutional by the Supreme Court in 2015 in the Shreya Singhal case. The Supreme Court issued a slew of directions to the Director Generals of Police and Home Secretaries of all states to ensure that reference to Section 66A is removed from all pending cases. The court also directed that the barracks of the IT Act must be published adequately to inform the readers that Section 66A has been invalidated. The Supreme Court in the case titled Commissioner of Service Tax New Delhi versus Quick Heal Technologies Limited held that educational trusts or societies which seek exemption under Section 10 subsection 23C of the Income Tax Act should solely be concerned with education or education-related activities. Where the objective of the institution appears to be profit-oriented, such institutions would not be entitled to approval. The bench of CJI UU Lalit Justices S. Ravinder Bhatt and P.S. Narasimha had observed. The Supreme Court in the case titled Commissioner of Service Tax New Delhi versus Quick Heal Technologies Limited has dismissed the appeals filed by the Commissioner of Service Tax seeking to levy service tax to the tune of over rupees 56 crores on Quick Heal Technologies Limited for its sale of antivirus software during the period between 2012 to 2014. The court held that the sale of the software in CDs and DVDs is a sale of goods, and once a sales tax has been paid on the sale consideration, service tax is not leviable on the same transaction on the ground that updates are being provided to the customer. Observing that there cannot be fraternity unless different religious communities are available to live in harmony, the Supreme Court of India in the case titled Shaheen Abdullah versus Union of India has issued a set of interim directions in a plea to curb hate speeches in the country. A Supreme Court bench comprising Justices K.M. Joseph and Rishikesh Roy directed the governments of NCT of Delhi, Uttarakhand and Uttar Pradesh to file a report before the Supreme Court regarding the actions taken on the hate speech crimes which have happened within their jurisdiction. Importantly, the Supreme Court also directed that these governments should take suo motu action against any hate speech crime without waiting for any complaint. The Supreme Court Constitution Bench in the case titled Janhit Abhiyan versus Union of India has by a 3:2 majority upheld the validity of the 103rd Constitutional Amendment which introduced 10% reservation for economically weaker sections in education and public employment. While Justices Dinesh Maheshwari, Bela N. Trivedi and J.B. Pardiwala upheld the Constitutional Amendment, Justice S. Ravinder Bhatt wrote a dissenting judgment to strike it down. Chief Justice of India, U. Lalit, had concurred with the minority view of Justice Bhatt. A Supreme Court bench comprising Justices S.K. Kaul and A.S. Oka in the case titled Re-Policy Strategy for Grant of Bail has issued a set of guidelines for disposal of criminal cases by resorting to the triple method of plea bargaining, compounding offences under the Probation of Offenders Act 1958. The Supreme Court in the case titled State of Jharkhand versus Shailendra Kumar Rai has prohibited the two-finger test in rape cases and has warned that persons conducting such tests will be held guilty of misconduct. It is regrettable that two-finger test continues to be conducted even today. A bench comprising Justices D.Y. Chandrachud and Hima Kohli has lamented while restoring the conviction in a rape case. Almost 30 years after the communal riots which rocked Bombay in 1992 to 1993, after the demolition of Babri Masjid, the Supreme Court in the case titled Shakil Ahmed versus Union of India has issued a slew of directions for payment of compensation to the families of victims and for revival of criminal cases which are lying dormant. A Supreme Court bench comprising Justices S.K. Kaul and A.S. Oka observed that there was a failure on the part of the state government to maintain law and order and to protect the rights of the people guaranteed under Article 21 of the Constitution of India. In a crucial judgment, the Supreme Court in the case titled Employees Provident Fund Organisation versus B. Sunil Kumar and Connected Matters held that the provisions of the Employees Pension Amendment Scheme of 2014 to be legal and valid. However, so far as the present members of the fund are concerned, the Supreme Court has read down certain provisions of the scheme, while allowing the appeals filed by the Employees Provident Fund Organisation and the Union Government challenging the Kerala, Rajasthan and Delhi High Court judgments which had previously quashed the Employees Pension Amendment Scheme of 2014. The Supreme Court bench comprising CJI U. Lalit, Justices S. Ravinder Bhatt and Anuradha Bose read down certain provisions of the scheme. The Supreme Court in the case titled State Bank of India versus Assistant Commissioner of Income Tax has observed that leave travel concession, that is LTC, is not for foreign travel and is meant for travel within India. The moment employees undertake travel with a foreign leg, it is not a travel within India and hence not covered under the provisions of Section 10, Subsection 5 of the Income Tax Act. Education is not the business to earn profit. The tuition fee shall always be affordable, the Supreme Court remarked in the case titled Narayana Medical College versus State of Andhra Pradesh, while setting aside a government order issued by State of Andhra Pradesh that had enhanced the tuition fee of private medical colleges by 7 times to Rs 24 lakhs per annum. A Supreme Court bench comprising Justices S.K. Kaul and A.S. Oka in the case titled The Advocates Association Bangalore versus Sri Barun Mitra has passed a stern order slamming the central government for withholding approval for names reiterated by the Supreme Court Collegium for appointment as judges. While expressing disapproval of the centre's inaction, the Supreme Court stated that the collegium system has sufficient checks and balances. The court made these observations while considering a contempt petition filed by the Advocates Association of Bangalore against the centre for not acting as per collegium reiterations. In a subsequent order passed in the same case, the court had highlighted the issue of advocates becoming reluctant to accept offer for judgeship due to delay in clearing appointments. The court also reminded the centre that the memorandum of procedure for appointment of judges has been finalized by the collegium way back in 2017. The Supreme Court in the case titled Maharashtra State Board of Waqfs versus Shaikh Yusuf Bhai Chawla clarified that all Muslim public trusts will not amount to a waqf. A bench comprising Justices K.M. Joseph and Rishikesh Roy said that there is a difference between waqf and a public trust created by a Muslim. Hence, the Supreme Court cannot paint all Muslim public trusts with the same brush and treat them as a waqf. The Constitution Bench comprising Justices Abdul Nazir, B.R. Gavai, A.S. Bopanna, V. Ramasubramaniam and B.V. Nagaratna in the case titled Shukpal Singh Khera versus State of Punjab has held that the power under Section 319 of the CRPC is to be invoked and exercised before the pronouncement of the order of sentence where there is a judgment of conviction of the accused. In the case of acquittal, the power should be exercised before the order of acquittal is pronounced. Hence, the summoning order has to precede the conclusion of trial by imposition of sentence in the case of conviction, the Supreme Court has ruled in this judgment. The Constitution Bench comprising Justices Abdul Nazir, B.R. Gavai, A.S. Bopanna, V. Ramasubramaniam and B.V. Nagaratna in the case titled Niraj Datta versus State has held that direct evidence of demand or acceptance of bribe is not necessary to convict a public servant under the Prevention of Corruption Act and that such fact can be proved through circumstantial evidence. Even if the direct evidence of the complainant is not available owing to death or other reasons or the complainant turning a hostile witness, there can be conviction of the public servant under the Prevention of Corruption Act if the demand for illegal gratification is proved through inferential evidence based on circumstances. Presumption of fact with regard to demand or acceptance may be made by a court of law by way of an inference only when foundational facts have been proved, the Supreme Court has ruled. The Supreme Court in the case titled Kamala Neti versus Special Land Acquisition Officer has held that a female member of the scheduled tribe is not entitled to any right of survivorship under the provisions of the Hindu Succession Act. The Supreme Court bench of Justices M.R. Shah and Krishna Murari urged the central government to consider whether it is necessary to bring a suitable amendment to the Hindu Succession Act in this regard. The Supreme Court in the case titled Anjali Bhardwaj vs CPIO dismissed a petition which sought for details of the Supreme Court Collegium's meeting of December 12, 2018 under the Right to Information Act, observing that the discussion cannot be disclosed to the public and that only the final decision of the Supreme Court Collegium needs to be uploaded in the website. The court observed that only the final resolution can be considered as the decision, and whatever is discussed is not required to be in public domain under the RTI Act. Thank you, dear viewers. Stay tuned to LiveLaw for more such updates.